Swayam Prabha. Digital India. Educated India.
I extend my warm greetings to one and all. Once again, I welcome you all in the lecture series of law and banking law and negotiable instruments. I am Dr. Raju Maji, Assistant Professor, Faculty of Law, Banaras Hindu University. Now, in the lecture 14, the very important aspect I am going to discuss with you. Dear students, we have discussed in the two lectures that is based on the negotiable instruments. But we cannot leave this particular aspect because there is lots of changes has taken place, and that to make accountable both the drawer, particularly the drawer in case of the check. So that's why I think that there is a requirement of the you can say the deep discussions about the check. So in this lecture, the scheme which I have prepared to better understand that this particular topic, that is check and dishonoring of check. So I'll discuss in the four heads, the one that is meaning and definitions of check, the characteristics of check, dishonoring of check, and the last one that is very important, that is the criminal liability under section 138 of the Negotiable Instruments Act 1881. Now, the dear students, let me start by saying that there are the two kind of, you can say that the compensation can be done, and that is compensation when we are talking about that is a part of the civil remedies. But as my concern, when we are talking about the criminal, then we are talking about the punishment. So the major changes have taken place as my question to ensure the payment, as we have discussed earlier, that the one of the liability towards the maker of the instruments, that he has to ensure the payment should be made the persons either by the drawee or if the drawee in case of failing to discharge his duty, then it is the duty lies towards the maker, or you can say the drawer, that he has to realize that payment. So in this background, as I have told you that in the present time, if you will see the check is one of the very you can say the prominent or acceptable negotiable instruments. As my concern, that the other negotiable instruments that is normally used by the banking sector itself, or to some extent we find that these are existing in the business community. But as my concern, the check now even it is commonly accepted by the common people also. And we know that the banker, as my concern, in the present we cannot imagine our day-to-day life. We cannot you can say live without the help of bank, because the bank now it is in our pocket, that we are doing all kind of you can say transactions, we are doing all kinds of purchasing, we are doing all kinds of payments, whatever we wish to do it, we are doing through our mobile. So that means we can say that we are putting the bank in our pocket itself. So in above that, the check plays a very significant role, as my concern, for making payments or discharge the liability, that instruments help you to discharge your liability. But failing which, that it is not only the civil liabilities, nowadays it is the criminal liabilities also. So we will discuss the one by one, that how what are the situations, what are the circumstances why this is be taken as a you can say the criminal liability. And the answer is that accountability to ensure the accountability, or to engage or involve to make payment in a proper manner or the proper way. So we will discuss entire means the topic in four heads, that is the meaning and definition of check, characteristics of check, dishonoring of check, and criminal liability under section 138 of the Negotiable Instruments Act. Now the meaning, as we have already discussed, but again I would like to tell you that the new things which has been added as concern to defining the check. Before the e-banking, concept of the e-banking, there were no such kind of the things were required. But as far as concerned that when the banking sector entered into making transactions with the electronic means, or by applying the you can say the electronic banking, so the definitions is also little bit they change it, and they incorporated under the definition of you can say the image of a check, or you can say the truncated check that is added. So, section 6 of the Negotiable Instruments Act 1881 state that a check is a bill of exchange drawn on a specified banker and not expressed to be payable otherwise than on demand, and it includes the electronic image of a truncated check and a check in the electronic form. So, in both the circumstances we find that not only it is available in a you can say the traditional modes, but now it is also accepted under the definitions of a check, or it is incorporated under the definition of check, that is electronic forms, or the truncated check is a part of the definition. So, a check being a bill of exchange must possess all the essentials of a bill, and in addition it must be drawn upon a banker. Secondly, the check must be payable on demand. It includes the electronic image of truncated check if it may be in the electronic form. These definitions were substituted place of all sections of the Act by the Negotiable Instruments Amendment and Miscellaneous Provisions Act 2002, because another 2 year 2000 we got a particular act as concerned to some extent to regulate the electronic by making the signatures and the other things. The bank also introduced with the help of the Information Technology Act, and in accordance with the these particular provisions as little bit you can say the change through the amendment in the year 2002. Now, to understand that what is the check, and when we are talking about the check, then I have told you that it is an unconditional order. That unconditional order is made by the drawer towards its drawee, and here in case of the check, the drawee is always a specified banker. So, in the bill of exchange any persons can be drawer and drawee, but in case of the check the only the customers of a banker and the banker in between these two can be the drawer and drawee. So, the characteristics of or essential requisites of a check, these are very important. We will have to discuss in a very brief, because we have discussed, or we have already discussed when we have discussed the negotiable instruments. So, the first and foremost thing that it must be in writing. The second thing is that a check is a negotiable instrument. I will discuss again. A check is a bill of exchange, but every bill of exchange is not a check. The fourth one is a check is always payable on demand, and the fifth one is a check is always drawn in the form of an order, and that order is conditional in nature. That means the drawer of a check cannot direct a banker to make payment to the payee of the check subject to certain conditions to be fulfilled by the payee to receive the payment. A check is an unconditional order from the drawer of a check to the drawee bank to make payment of money only. A check is always drawn on a particular bank only. A check must be made payable to the order of a certain specified person or to his agent or to bearer thereof. Sergeant Paget said that the nominal check is one in which there is a drawer, a drawee, banker and a payee, or no payee but the bearer. The amount to be paid as indicated in the check must be certain and specific. The amount should not be left to be determined by the drawee bank for payment. And the last one is the check must be signed by the drawer, that is the customer. The drawer normally puts his signature at the bottom right hand comes in the check. The signature must be that of the person in whose name the account is kept or his authorized agent. Now, I am coming to one by one that the essential things. It is very important to understand the check, that what do you mean by it. Check, as far as concerned, that when we are talking about that the existing relationship between the drawee and the drawer, between the customers and the banker, The check means which is prescribed by the banker to its customers, and the customers has a right to make an order in that form only. It is not a bill of exchange that the persons can write itself or persons can prepare itself. If the check is not issued by the banker to any of its customers, the customers cannot take the check from any other persons, and he is not entitled to issue that check because he is not authorized. That means a check must be in writing here means the check must be obtained from the bank and it must be issued by the concerned customers. If when he can issue that, when the customers having the check facility and customers obtain in his name a check from the concerned bank, or we can say from the drawee banker. A check is a negotiable instrument. When we are talking about the check is a negotiable instrument, that means the check must possess all the characteristics which is required. What are the characteristics of negotiable instruments? That is unconditional one, that is in written form, that is the parties must be specified, that must be issued for, or that must be prepared for the money only, and the finally that the signature of the maker is very important. So, all these aspects are also essential as far as concerns when we are talking about the check. That is why that one of the essential characteristics of a check, that is the negotiable instruments. Check is a negotiable instrument. As soon as we are talking about the negotiable instrument, that means it must comply all the characteristics which is required for what to be called a negotiable instruments, which we have discussed at length. The third one is a check is a bill of exchange, but every bill of exchange is not a check. Now, a check is a bill of exchange, but every bill of exchange is not a check. The reason behind it, as my concern that when we are talking about the practice between these two, in case of the check, it is already we have discussed that the parties are not, we cannot say that any persons can be the drawer. The only that the drawer and drawee relationship is established between the customers of a banker and his the concerned bank. But as far as concerned, on the other hand, when we are talking about the bill of exchange, any persons can be drawer and drawee, subject to in between these two persons if there are creditor debtor relationship is established. A check is always payable on demand. As far as concerned, when we are talking about or when we are comparing with the bill of exchange, then we find that the bill of exchange cannot be claimed as a demand. There are the maturity date might be there, or we can say that the acceptance is required from the drawee. But in case of the check, no any source of acceptance is required from the bank. The drawer has a right that he has to issue a check. It is an order and the payee can make demand, but as far as concerned the procedure how the demand can be made, that has been discussed earlier also. Again, I would like to put before you that the payee must present the check in a proper manner, in the proper way. The proper manner means that without any kind of mutilated, without any kind of you can say the destroying the check or altering the check, he has to present during the banking hour, and he is entitled to get payment. If the check is dishonored by the banker, the persons who is the drawer is liable and the payee can claim from the drawer, not from the drawee. Check is always drawn in form of an order, and that order is conditional in nature. That means the drawer of a check cannot direct a banker to make payment to the payee of the check subject to certain conditions to be fulfilled by the payee to receive payment. There is no any kind of the conditions can be made. A check is an unconditional order from the drawer of a check to the drawee bank to make payment of money only. So, whatever the term which you have used, the apparent tenor. So, the money which is appeared, but as I have told you that if there are any sorts of you can say the alteration or mismatch is found, it is a subject matter of again the dishonour, and the paying banker will dishonour on the basis of it. If it is not there, then you will have to make payment. The seventh one is talking about the check is always drawn on a particular banker only. As I have told you that the drawer and drawee is the customer and a specified banker. So, that one of the characteristics of a check is that a check is always drawn on a particular banker only. The eighth one is, as you have discussed, again I would like to put before you, that is, a check must be made payable to the order of a certain specified persons or to his agent or to the bearer thereof. Whoever made, whose name is appear in the check, or the who is holder of the check, he can present and he is entitled to get payment. Then the amount to be paid indicated in the check must be certain and specific. The amount should not be left to the determined by the drawee bank for payment, but as we know that the check might be that the blank check will be issued by the by the drawer, that is possible. But when the payee is presenting before the bank, the payee cannot leave he cannot leave the check in that circumstances. He has to fill up that amount what he required, what amount he is willing to get from the bank. So, that must be mentioned in the check itself, otherwise the banker is not liable to pay. So, the specific amount must be mentioned there. And the last one, as I have told you, that it is a very important, even the check must be signed by the drawer, that is the customer. The drawer normally puts his signature at the bottom right hand comes to the check. The signature must be that of persons in whose name the account is kept or his authorized agent. So, in case of the you can say the artificial persons like the companies and any kinds of the authority, if they have opened their account in the name of the authority, any partnership forms, if they have opened their account in the name of the partnership form, at the time that the persons who is authorized as an agent to discharge his duties, he is entitled to put his signature on the check, and in other cases, or you can say the normal cases, the signature must be put by the customers of a bank only. So, there are certain circumstances under which a check can be dishonored. Now, there are not a simple reason, or there are not a single reason on which a check can be dishonored. As a paying banker, as I have told you, that the paying banker is liable to honor the check under section 31 of the negotiable instruments. There is no doubt about it, it is very clear. But at the same time, when we are talking about that the banker, when he is discharging that duty, the banker has to ensure the payment is made in a proper way, and the banker will always put his conditions, or you can say himself, that to follow the procedure for making a payment. And for that reason, there are several grounds which has been stated. On any of the grounds that the check can be dishonored. So, only I am going to read out before you that the circumstances where we can say in which a check can be dishonored. On the other hand, as you have seen that the duty lies towards the paying banker under section 31 of the negotiable instruments that he has to honor. But when he will find that the check is under these circumstances, he will dishonor it. Dishonor here means that he will not make payment. He will return with mentioning the reasons for dishonoring or for non-payment. So, these are the circumstances. The first circumstances is when there is no sufficient funds to meet the check. It is one of the important, we will discuss later on also when we will discuss the section 38 at that time, but that means there is no sufficient fund. This is one of the ground on which the check can be dishonored. The second one is when the countermarks of the payments, that means the customers might issue a check and that he send a notice to the banker that not to honor it, that is the countermarks of the payments. The third one is no countermanding payment of a demand draft. The demand draft, as we know that the demand draft is already issued to someone, and it is once the payment has been means the draft has been issued, that cannot be withdrawn unless and until that the persons is asking to whom in whose favor the check draft has been made. Fourth one is the correctness of the check. That is very important as my question. This is one of the ground on which the paying banker easily you can say the dishonor of the check, the correctness of the check. There are many regions where we find that maybe there is a mismatch of you can say the amounts in words and figure. There may be the signature is mismatch. So, the many you can say the technicalities are there on which if the check might be mutilated and it is presented. If there is we can say that the signature is putting by some other persons or even by the drawer itself, but he might have the 2-3 signatures and he put the wrong signature over it. So, that the correctness of the check is very important. Check not properly presented, when we are talking about the check not properly presented, then the two circumstances which we can understand. The one circumstances is that where what happened, the drawer when it given to the payee might have not presented during the banking hour, or the payee might have not presented within the validity period, or there may be the reason that he is presenting a post-dated or predated check. So, these are the grounds on which that the check can be called that the check is not presented properly. So, this is another grounds for dishonoring. Crossing of a check, as we know that if the check is crossed one, paying banker will not entertain it. Who will entertain? The collecting banker will entertain. So, it depends on that what kind of the check you have when you are presenting. When you are presenting as a cross check, and if you are not a customer of that bank, the banker will not act as a collecting banker. To act as a collecting banker, the customers must deposit that check on his the bank where the customers has its own account. Closing of account, if the customers close his account and if the check is presented, so it will be dishonored by mentioning that the closing of an account. Death of a customer, if the banker receive a notice that the person died, in the circumstances that the check will be dishonored. When the customers become insolvent, the insolvent is declared by the court. If it is notice received by the banker that the person has been declared as an insolvent one, immediately that the bank will dishonor any of the check which is presented by anyone, any payee. The further it is talking about the notice of customers insanity or leniency. If the notice is given that the person is now is not in a you can say the sound mind, in the circumstances again that the check can be dishonored. The court orders that is if suppose any kind of you can say the order which has been made by the court, particularly the court is making an order which we are calling the garnishee order as far as concerned that the banker, if any kind of the garnishee order which has been received by any of the bank, so the bank will dishonor the check. Attachment under income tax, the income tax is an authority where if he needs some sort of you can say, or the investigations are going on a particular account, then he can ask to the banker that for the few circumstances or you can say the few moments to put the account in a siege unless and until that investigation is complete. Then the persons belonging to enemy country, if it is only happened that when if there is a war between the two countries, and if the customers is belong to the enemy country, the check can be dishonored on the basis of that. The defective title, if the person is not, but as far as concerned, as I have told you, that is very difficult for the banker to determine it that whether there is a defective title or there is the person who is presenting, he is entitled to get it. Forgery, it's again another that the signatures can be forged, the amount can be forged. So, in that circumstances, if the banker having any kind of you can say or any sorts of you can say the doubt over that, the banker can dishonor it. When check is post dated, I have already discussed with you. When check is of doubtful, that is sometime that might you have not informed, you have issued a check that is bearer check and you have lost somewhere, and you have not you can say that notice to the banker, and if the stolen check was found by someone and he might have deposited. So, it is again that as far as the title of that person, so whether he is entitled or not, bankers is doing only one thing, that he is taking signature of the pay and he is making payment. So, mostly the bankers cannot be held liable for that, but if the banker has some sort of the doubt, then he can, in a, you can say, if check is in a doubtful, that he can return without payment. If the cross check is presented at the counter for immediate payment, as I have told you that the you cannot demand a fund concern that in case of the cross check, you will have to the bank will act as a how that the collecting banker, as you have seen, that the collecting banker will do its work. The collecting banker will act as an agent. He will collect money, then only he will be allowed to customers to withdraw the money. If the check is presented during the non-banking hours, it is very important nowadays. Earlier it might be little bit it is possible, but now any transactions when the bank is doing, immediately it is recorded in the computers itself that at what time it is presented. So, the bankers if they wish to help you, but they are helpless, if you are going beyond the banking hours or out of the banking hours, they will not entertain, and it is a subject matter of, you can say, the dishonour of check. If it is mutilated, I have already discussed with you. If the check is an ordinary piece of paper, if you do not have a leaf, or the leaf is suppose the over, you do not have check at the time, then you are making the content of the check, because you know that you are making that content, and by putting your signature, if you are submitting, that will not be accepted, that will be dishonoured. And if it is conditional one, if in the check when you are giving to the pay and you are making some sort of, you can say, the conditions over it, that okay, subject to compliance the certain things, that the check can be honoured, in the circumstances it will be dishonoured. So, these are the regions on which, that means there is not only the single region, there are several regions where the bank can dishonour the check. So, when the check is dishonoured, the bank may returning, or the paying bank may returning with the certain some sort of the reasons which I have just, I would like to, that the things, the circumstances which I have read, the bank will return it. Every bank has you can say the leaflet under which these are the circumstances are available in the printed form. He will attach and he will put a tick mark on the specific grounds on which he is dishonouring it. It is very important as far as the banker. So, providing reasons for dishonour of a check by paying banker. These reasons are that the not sufficient fund, check is post dated, check is out of dated date, amounts in words and figures differ, page endorsement required, page endorsement requires bank confirmation, refer to drawer, payment stopped by drawer, cross check should be presented through a bank, exceeds arrangement, alteration required drawer's full signature. If any sorts of, you can say, alteration is there, then it can be corrected by putting the full signature by the drawer. So, if it is requires, on the basis of it, it can be written. The drawer's signature incomplete or differs or requires, because as I have told you that it is only one means which is available in the hand of the banker to ascertain or to certify that whether the check is issued by the right persons or not, that will be verified with the help of signatures only. So, whenever the banks has some sort of the doubt about the signatures that might be the incomplete or it differs or requires, then it will you can say the by returning the check by mentioning that regions, account closed, check is mutilated, drawer deceased, account attached. So, these are the grounds on which the check can be dishonoured. But I am coming to the last part of this, which is very important to understand, that is the criminal liability. The dear students, that sometime we have experienced that even the lawyers, they are not in a position to understand that particular provisions, but I like to, that is why I have discussed this section 138 in a very details or in the different way. That what are the requisites of section 138? Only the section 38 is talking about that the criminal liability can be imposed towards the drawer. So, that is very important, and as I have told you that it is bring under this the statute book, because it requires For what? For the accountability of a drawer, to establish the accountability of a drawer and the create the faith, the practice on a cheque, because the cheque, as I have told you, that it plays a very significant role. So, if we will see the before 1989 what happened, the persons, the drawer, they were very negligently act. If they do not want to, you can say, discharge their liability, they will issue a cheque, and when you will present, the bank will return it due to the insufficiency of fund. So, due to the insufficiency of fund is one of the essential things, or you can say the essential characteristics of section 138, that is very important. We will have to see that. The very next essential of section 138 is that cheque must be issued by the drawer in discharge of some sort of the liability, that might be the partial or fully. So, the cheque, if you have given someone in a gift or if you have donated, so that will not come under the section 138. That means, to ensure that 138 is very important, that cheque must be issued in discharge of some sort of the liabilities may be partial or you can say fully. So, these two things when you are establishing, then only we can say that you can have a right to initiate further proceedings as far as concerned to establish the criminal liability towards the drawer. So, by introducing this the provisions section 138 to 142, it enables, you can say, the payee to take action against the drawer in case of the non-payment, So, it plays a very significant role, and earlier I have told you that earlier there were, before 1989, there were only the civil liabilities were there towards the what we can say, towards the drawer of a cheque. But after amendment, that the criminal liability were imposed. The criminal liability here means again that there is a punishment, and there is a huge punishment, you can say, they impose apart from that your the civil liability which have. The civil liability means you will have to return the money. It was there, and even after introduction, or you can say the introduction of this 138, the same thing is remain there, but it is added that the drawer is liable for what? The criminal liability, or the payee can impose the criminal liability towards the drawer. But there is a process that has to be compliance, otherwise the 138 will not attract. What are this? I am coming to that. But before coming to that, I would like to, as I have told you, that 1989 the drawer of a cheque was subject to civil liability in respect of the money due on a cheque up to, we can say, the 1989, that what was the liability towards the drawer? That was only the civil liability. If it was dishonored for reasons whatsoever, whatever may be the reason, if it is dishonored, that only the civil liability were there. With enforcement of banking, public finance institutions and negotiable instruments law, Amendment Act 1988, on April 1st, 1989, dishonour of cheques because of insufficiency of funds was deemed as an offence for which the drawer may be punished with imprisonment for a term up to 2 years or with a fine which twice of the amount of the cheque or with both. Now, that the one thing which you will have to understand, that it was incorporated and it came into force in the 1st April 1989. By introducing this chapter, it is talking about that it is an offence. It is an offence and it is punishable, and the punishment, as I have told you, it is a huge punishment has been incorporated under this section, that the drawer, non-compliance of section 138, then non-payment or the dishonour of the fund for what? Then the very specifically mentioned that is that due to insufficiency of fund, that is very important. We will see that how the insufficiency fund, but as far as concerned the punishment, what is the punishment apart from the civil liability, that the criminal liability, that the punishment is 2 years imprisonment. The imprisonment can be extended up to 2 years, and the fine, that is the twice amount. If the cheque amount is ₹1000, then the 2000 fine can be imposed, or with both, that the imprisonment as well as the fine. And what is the fine's amount is? Fine amount is just double amount of the cheque. Such punishment will be in addition to the liability in a civil suit. Sections 138 to 142, which have inserted in the Negotiable Instruments Act 1881, provided for such punishment, provided the following conditions are fulfilled. As far as concerned, that as I have told you, that when you are going and if you are talking about, because they are not using the dishonour word, they are talking about that there is a bouncing of cheque. The cheque bounce, then what you can say the lawyer friends will tell you, they will tell you that okay, I will put that person's behind the bar, but it is not that exactly mean of the section 138. Section 138 is making accountable the persons, and it is not that by putting in the jail or putting behind the bar, it is not talking about that. It is talking about that in failing which, but when we are talking about the in failing which, then it has to be undergone through all the process which requires to attract, you can say that or to sue the drawer under section 138. Every circumstances it will not attract. So, dishonour may be the various reasons which I have already discussed with you, but only one reasons the section 138 is talking about if the cheque is dishonoured, and that is the insufficiency of fund. That is only the sole grounds on which we can say that the insufficiency of fund. But we will see later on, there are some of the judicial, you can say the decisions which is talking about the different things also on which we can say for the insured or for making accountable that particular the sections which have been imposed to make live. There are the few things which also attracted the section 138. But normally, if you go through the section 38, it is talking about the insufficiency of fund. That means, the first and foremost thing that you will have to see the cheque is dishonoured due to insufficiency of fund. As I have told you, there are other grounds are also there. There are the technical grounds are also there. If it is dishonoured by any of that grounds, it will not attract section 138. That means, the first and foremost thing that you will have to establish that the cheque was issued by the drawer for what? Discharge of the liability. If it is not issued for the discharge of any kind of the liability may be partial or liability may be full. The partial means, suppose your liability lies towards that person's, towards the 500 rupees, but he requested you to give me the advance 500 rupees. So, you have issued a cheque of the 1000 rupees, and when it is dishonoured, then you are saying that if I will issue the cheque of rupees 500 only, then there is no chances of the dishonour. So, that is not that kind of the execution not granted. That is the partially, even if the partially that comes under, or you can say that attract the section 130 of the Negotiable Instruments Act 138. The second thing it is talking about, that the cheque must be written by the drawee banker by mentioning that due to insufficiency of fund. It is the duty of the banker that to determine the insufficiency of fund. I have told you that the insufficiency of fund will be determined by the banker by the two way. The one way is that he will see what, that there is the credit balance is not available, the first thing, and if we will see that the credit balance is not available, then we will check the second one if there is any kind of the arrangement, and even if there is an arrangement that the amounts of cheque is exceeding that arrangement. So, in both these circumstances, the cheque will be written by the banker mentioning that insufficiency of fund. So, the cheque has been issued in discharge of a debt or other liability in whole or in part. It implies that a cheque given in a gift or donation will not attract the punishment. So, in a case, it is held by the Bombay High Court, held that banks cannot prosecute borrowers under this section if blank post-dated cheque issued by them as collateral security are dishonoured. The second very important thing as far as concerned when we are talking about to attract section 138, it is required the cheque should be presented to the paying banker in time. As far as concerned that within 3 months present time, that the validity of a cheque, or its a specific validity period whichever is earlier. In case of post-dated cheque, the period of 3 months is to be reckoned for the purpose of section 138A from a date which is written on the cheque. Giving the above verdict in Anil Kumar Sani versus Gulshan Rai, the Supreme Court held that a post-dated cheque remains available of exchange till the date written on it, and it becomes a cheque under the Act with effect from the date shown on the face of the said cheque. So, the 30 means 3 months time, that will be determined on the basis of the date which is appears in the cheque. The third very important thing, that when you are presenting the cheque, that you have to present in a validity period, within validity period. The third thing is talking about the dishonour of the cheque should be on account of insufficiency of funds only. That is very important, that there may be signature mismatch or the customer's account closed. So, that will not amount according to the section 38. But as far as concerned, that the third thing it is talking about the insufficiency of fund only. That is only one grounds on which if the cheque is dishonoured, then the drawer of a cheque is liable to be a criminal liability under this, but it is only possible when all the procedure which has been laid down under section 138, if it is complied by the payee, otherwise he is not liable for it. So, the dishonour of the cheque should be on account of insufficiency of funds only. Either the amount of money ascending to the credit of the drawer is insufficient, or the amount of the cheque exceeds the amount arranged to be paid from his account by an agreement with the bank. As I have already said with you, that the two, on the basis of it, the bank will determine whether there is a sufficient balance or not, or the sufficient fund is available in the end of the customer's account or not. The fourth one is the payee or holder in due course should give notice in writing to the drawer demanding payment within 30 days of his receiving information of dishonour. That is a very important duty which lies towards the payee, the persons who is presenting the cheque, the drawer or the holder in due, whoever may be, that as soon as you receive a cheque mentioning that the dishonour of cheque and it is written by the banker, that the bank along with the bank slip, it is very important, and under that the grounds has been mentioned that due to insufficiency of fund. That is very important. If in any other grounds 138 will not attract. So, as a payee, it is to see that when he received in that way, that the cheque has been written by the drawee banker without making payment. As soon as he received that, within 30 days from the receiving of that from the bank, means dishonour notice from the bank, within 30 days he has to issue a notice to the drawer. Now, the drawer can make payment within 30 days of the receipt of the notice. If he fails to do so, prosecution can take place. Now, that when the notice has been issued by the drawer, by the payee to the drawer, from what is the date? That from the date of receiving about the dishonour notice from the drawee banker, he has to issue a notice to the drawer informing that the cheque has been dishonoured by the bank and the reason behind it, that 138. So, 138 means insufficiency of fund, and the relationship are already established, that is issued by the maker to discharge his liability. So, that is very important, that has to be established. If all these things are there, then you can have the right, but as far as concerned the maker, when he is receiving that the notice, within 30 days he can return that money. Now, during that period, the payee cannot deny it to accept the payment. That your intention is that no, I will send you behind the bar, I will put you behind the bar. That is not available. It is only available if the after receiving the notice from the payee, if the drawer is failing to make payment or discharge his liability, that is to pay the money, failing which the prosecution can be initiated. So, before that the prosecution cannot be initiated. So, the very important thing is that is why I am telling you that it is not the purpose to send behind the bar. The purpose is to create apprehensions towards the maker. If you will not comply, if you will not do your duty, if you then against you criminal proceedings can be initiated, and that is why the time limit has been given, that within that period you have to make payment. and failing which it says the prosecutions can take place. That the complaint can be made only by the payee or holder in due course. The third party are not, it is not a public interest litigation. Only that the holder of the check, that the payee, he is only entitled to make a complaint. And when he can make a complaint, the first and foremost thing that he has to ensure that that the check is issued for discharging of a liability by the maker. The second thing is that the check was dishonored due to the insufficiency of fund. The third thing is that he has issued a check within the validity period, that is receiving from the notice of the dishonor within 30 days. He issued a notice to the maker, or you can say the drawer, and the drawer failed to make payment of that notice within 30 days from the receiving of it. When these 4 stages completed, then it is a subject matter of prosecution. Now he can start the prosecuting, and the complaint can be made by him only, not that is by the third party. So, in A.C. Narayan vs. State of Maharashtra, the Supreme Court held that a complaint about a bounced check can be filed by a power of attorney holder also. He can depose or verify on oath before the court in order to prove the contents of the complaint if he had witnessed the transactions as an agent of the payee holder in due course, the positions due acknowledge regarding the transaction. So, if someone is authorized, then by power of attorney, under the Maharashtra case of A.C. Narayan versus State of Maharashtra, the Supreme Court enable the persons as a power of attorney that he can have the right to sue or to make a complaint. The complaint is to be made within 1 month of the cause of action arising, that when the 1 month time is completed. So, you cannot wait for the longer time. So, if the drawer is failed to comply the provisions of the section 138, what is that? That from the date of receiving the notice of dishonor from the payee, he has to discharge his duty. What is the duty? That to make payment. So, failing which, that within 1 month the complaint has to be lodged before the appropriate authority. The complaint is to be made within 1 month of the cause of actions arising, that is expiry of 30 days time to the drawer to make payment. The 1 month has to be calculated by excluding the date on which the check was dishonored. The court shall have the discretion to waive the period of 1 month prescribed for taking cognizance of the case under the act. It's little bit the discretion power has been conferred, but the procedure is laid down that as soon as the cause of action when it will start, as soon as that the 1 month time, that is 30 days times will expire. From that date, you are entitled to file a complaint against the maker for non-payment of a check. Where is the jurisdictions? It says the no court lower to the metropolitan magistrate or judicial magistrate of first class will try the offence. Summary trial of the cases may be undertaken by the court with a view to speed of disposal of the cases. A trial is expected to be calculated within 6 months of filing a complaint. A complaint can be filed in any of the jurisdictions where the transactions took place, including the place issue and the place of dishonor. But with the amendment that now the where the check is issued, that will be the place, but as far as the earlier practice, that in both the places the complaint can be lodged. Where that the authority is in case of the metropolitan city, then the metropolitan magistrate. In other cases, the judicial magistrate of first class, they are entitled to entertain the complaint. The offences under the act are made compoundable. The directors who are nominated as directors of a company by virtue of their holding any office or employment of the central or state government or a financial corporation owned or controlled by the central or state government are exempted from the prosecution under section 141 of the Negotiable Instrument Act 1881, because they are why? Because it is if there is no fund, so personally he is not liable for it, so that the exemptions have been made if the persons, the directors who are nominated as directors of a company by virtue of their holding any office or employment in the central or state government or a financial corporation owned or controlled by the central or state government are exempted from prosecutions under section 141 of the Negotiable Instruments Act 1881. So, you will have to see that the persons whose check is going to be dishonored, the pay is not entitled. For example, suppose the company or the financial corporations which is owned by the central or the state government, the discharging his duty, if the directors who is nominated for that purpose, he issued a check and due to insufficiency of fund, if it was dishonored, so the directors cannot be held liable for it. Why? Because the exemptions has been granted under section 141. In remaining cases, or you can say the other cases, all persons means all the drawers are comes within the purview of section 138 and the criminal proceeding can be initiated against their act or offence. Now, what is very important that when you are receiving a check from the bank, when the bank is returning without making payment, at that time it is very important that you will have to accept with the reasons. So, why? Because you have to comply, you have to accompany it when you are filing a suit against the maker before the bank after going through or completing all the you can say or complying all the procedure which is required under section 138 of the act. So, it says the bank slip denoting that the check has been dishonored shall be considered by the court sufficient proof of dishonour until such fact is disproved. So, it is sufficient that the slip which you have received from the banker, that is enough as far as concerned to establish that the check was dishonored due to insufficiency of fund, unless and until that the reasons which is made by the banker, it is disproved. How it is disproved? Only one thing, that if the bank act negligently, in that cases the customers is entitled to claim compensation from the bank itself. The drawer has a right in case of if the bank negligently dishonored it. There are the reasons. With that circumstances, if he is dishonoring, it is all right. There is no any kind of, you can say the compensation claim can be made against the banker. But if the banker act negligently and any loss occurred or the damages occurred, then the customers, means the drawer of a check, has the right to sue against the drawee bank to get the compensation, and the drawee bank is liable to compensate the customer, or you can say the drawer of a check. The summons may be served by a speed post or approved courier services. That the notice, it is talking about the notice, is very important. Section 140 makes it quite clear that the drawer of the dishonored check cannot defend himself on the ground that he had no reason to believe when he issued the check that the check may be dishonored on presentations on account of insufficiency of funds. So, it cannot be taken as a plea that I do not know that when it was means the issued and when it was presented, because once you have issued the check, you will have to ensure that there is a sufficiency of fund, because you cannot direct the payee. The payee in his wish, he may deposit at any time, but you cannot ask that you deposit tomorrow or today. If you wish that, then you can issue or you can put the date in that way. So, it is very interesting to note here that an offence under this section is committed only when the drawer of the check fails to make payment within 30 days of receipt of notice and not immediately on the dishonour of check, because dishonour of check by itself does not give rise to cause of action. Payment can still be made within 30 days of the receipt of notice of demand. That is very important. As I have told you that 138, it is all right, there is no problem, but the compliance, that is that give an opportunity to the drawer. Drawer, if he is failing from the making the another demand, you can say, by the drawer by issuing a notice, and if within 30 days if he is failed to comply that, then only the proceedings can be initiated. The service of notice is must it is essential that notice of dishonour of the cheque is served on the drawer. The notice may be sent by fax as well. When notice has been served, that then once the period limitations for filing complaints under section 142 clause A commences from the date of receipt of first notice by the drawer. It was decided in the Silk Import USA versus Exim 8th Silk Exporters Bangalore. In another case, again it was decided in the case of V. Kishore versus S. Ajay Kumar and others. The Andhra Pradesh High Court held that the period of limitations for sending of notice of dishonour of a cheque does not start from the date of oral information, but from the date of written information from the bank given reasons for the dishonour of the cheque. So, that orally information is not accepted. You will have to issue a notice through which you have to make a demand that you will have to pay because it was dishonoured by the bank, and the reason behind it due to insufficiency of fund. In other, that the bank will issue, the drawer will issue the another cheque by removing the regions on which the cheque was dishonoured. In MS Balichand Gyanchand and Company versus Chinnaswamy, the Supreme Court observed that where a cheque issued by a company is dishonoured because of insufficiency of fund, a notice of the managing director of the company under section 138 is sufficient, even if no separate notice has been sent to the company, because the account is run by the company's name. So, it is not necessary that the notice will be served to the company itself. It is sufficient if the notice is served to the director or the managing director, whoever may be the concerning authority or authorized to issue the cheque. The criminal liability in case of the stop payment of a cheque and other regions. They are the two very important things which have been mentioned. I like to cite before you. That is the Electronic Trades and Technology Development Corporation versus Indian Technologists and Engineering Electronics Private Limited. And another case which is very important, that is Modi Cement Limited versus Kuchil Kumar Nandi. In this case, it was mentioned that stoppage of payment is also attracting what? That is the section 138 of the negotiable instruments, which establish the criminal liability towards the drawer. Why? Otherwise, it says that if we will allow, that what the persons will do, the persons will issue a cheque and the next time he will send a notice to the banker that not to pay it. So, in these two cases, both the cases, it was found, particularly the Modi Cements and Kuchil Kumar Nandi, it was held by the court itself that the stoppage of payment is also attracting section 138 of the negotiable instruments. It says the court held that the decisions of in clause B, that is the stoppage of payment by the notice to the banker, object and purpose for which the chapter 17 containing section 138 to 142 has been brought on the statute book, if it is accepted as good, the very object of introducing section 138 would be defeated. So, that is why knowingly the court moved forward, which is not mentioned under section 138, and it is talking about that the intentionally, if the things has been made and it is not informed, and even if it is informed, that if we will allow the persons to stoppage of payment, then it will again the bad practice will start, and the objective of the 138 will be going to defeat it. So, in that way, as I have mentioned, that it is one of the things which is very important as my question to ensure or to make accountable towards the liability under the cheque as a drawer, that the criminal liability provisions has been imposed, and after this we can find that there is less kind of, you can say, and the faith is increased as far as the use of cheque or acceptance of cheque. With this, I would like to thank you